Now is the time for the second talk of the event, and I would like to welcome Professor Gregory Lewkowicz. He is a professor at the University of Brussels, ULB, and director of the Global Law Program of the Perelman Center. He holds the Alexandre Chair of Excellence in Economic Law and Artificial Intelligence at the University of Nice, Sophia, Antipolis. He also teaches the interaction between law and technology at the Sciences Paris Law School as a part of the Master in Economics Law and Paris Panthéon Assas as a part of diploma in digital transformation of law and legal tech. Now we welcome Professor Lewkowicz.
Thank you very much for this introduction. So what I would like to discuss with you today is what AI does to law, actually, and what law should do to AI. So I would like to go in both directions. Just introducing myself, I'm working in the Perelman Center at the University of Brussels, and working especially in what we call the Smart Law Hub. We'll explain a little bit more what smart law means in our perspective. And the idea of the Smart Law Hub is that we have Smart Law Hub in different universities. There is Smart Law Hub in Brussels, there is Smart Law Hub at HEC-Paris, there is a Smart Law Hub at Institut Polytechnique de Paris, in order to bring together different kind of expertise that we need in order to address questions that are at the intersection of law and, let's say, AI in a broad sense. Sometimes it's only computer science in general. This is something that we have done because for already like a little bit more than 10 years, we are quite convinced that we need to have more understanding and more capabilities to look into what we can do with computer science in law and how to adjust and put pressure to a certain extent on computer science so that computer scientists change also sometimes the way they are working. So what we are doing is we do research, of course, we build solutions, and we bring expertise to public and private organizations on these aspects, working on basically legislation, conflict resolution, and judiciary, and compliance. This is the three kind of broad dimensions that we are working on, trying to assess legislation, to measure the complexity of legislation, trying to provide court with some tools like large language model to do specific kind of operations, or trying to help companies or even universities in being compliant with digital regulations that we have more and more. So I would like to tell you something about a tale of two arrogant mindsets. I mean computer science and legal. It's two different mindsets, and they both imagine that they can solve everything in the world alone. On the one side, you have the legal mindset. They think that with three concepts, basically, you have persons, you have things, and then you have legal obligations. And whatever problem you have, you can go to a lawyer. He will tell you, yes, of course, this is the person, this is the thing. Then this is the relation between the person, this is the relation between the thing, and this is the solution to your problem. We will apply this law. I would say computer science is not that different. They say, okay, but let's see the problem. What is the problem? You have data. These data are processed, and then there is data out as an output. Then we can do a little bit more calculation or computation. Then we process this data. We have another data, and at some point we will solve your problem. And then, of course, looking one to the other, the idea is that for lawyers, digital technologies is just another thing that should be regulated by law. And from the perspective of computer science, law is nothing but data and data processing, and of course that needs to be optimized because it doesn't work well. So having this kind of small story in the background, I would like to show you some aspect of what AI does to law. And I like to use this example. It's already a little bit old, but it's very clear. So some of you remember maybe that some years ago, was a huge topic regarding the regulation of high-frequency trading. High-frequency trading was a very complex topic for financial regulation because you have traders trading at the nanoseconds, leading to some kind of abrupt rise of potential in a kind of ecology of the financial system, because you can see on this paper that was published in Nature that in fact with all the high-frequency traders playing with the machines, you had a stability of the financial market that was moving all the time. It was never really stable. It was always like this, and sometimes whoop, you had a big problem that was the fast crash. So the question was, how can we regulate this kind of behaviors, and how can we regulate high-frequency traders? And on this point of view, we had several cases. One of the first one that was the first one that was adjudicated was the Koskia case with Panther. And what Koskia was doing, Mr. Koskia, with he was basically doing something that looks a lot like, and it was considered that it was spoofing, was sending orders on both sides of the order book in order to give the impression that there was an interest in buying here, while what he wanted to do is only to pass some orders on the other side. And then when people decide to try to buy, he was canceling the order and passing these ones. So this is market manipulation. But the problem is that market manipulation is defined by through the notion of intent. And it was a lot of discussions for the different supervisors to see how they can apply exactly the financial law and market manipulation rules to this kind of problem. So finally, in June 2013, there was a decision that, in fact, it's not really important to find a real intent. What is important, that was a decision of the Financial Conduct Authority, is that at least we have the impression the point is that it's enough that the system gave or were likely to give a false or misleading impression as to the supply of or demand for the price of the commodities futures on ICE. So the idea was that they escaped the problem of proving, of demonstrating, of bringing evidence for intent, showing that in fact, if you have basically this kind of pattern, we can consider this market manipulation if you have this pattern repeating itself again and again. But of course, that was only a solution for this case. After that, we had a lot of new regulation that were adopted in the US, in Europe, and providing specific rules for algorithmic trading. So, for instance, you had MiFID II, and in MiFID II, Article 17, you have this idea that if you have an investment firm that engage in algorithmic trading, including high-frequency trading, they should have in place effective system and risk control. And the idea is that these effective systems and risk control should ensure that the trading system cannot be used for any purpose that is contrary to regulation. So that is a very high standard to ask, because the idea is that you should test the machine, you should test your system, so this system cannot break the law. In market abuse regulation, another one that comes a little bit later, was the same idea that market operators and investment firms should establish and maintain effective arrangement system and procedures preventing and detecting insider dealing, market manipulation, and attempted insider dealing and market manipulation. So they was putting a lot of constraint on the different operators, saying, okay, you have this algorithmic trading, that's nice. Let's develop. You have to develop systems to guarantee that they will not break the law. How you do that? That's a different question. And the European Commission has adopted regulatory technical standards on organizational requirement of regulated markets. And in this one, you can see that what the idea of the Commission is that trading venues will have to require their member to certify that the algorithms they deploy have been tested to avoid creating or contributing to disorderly trading conditions. That means that you need tests, you need certification, and these tests and certification aims at guaranteeing that you will not break the law. And the idea is that this testing for disorderly trading condition includes recreate real market conditions to ensure the well-functioning of algorithm under changing circumstances, and must include tests and show that the algorithm can continue to work effectively in stressed market conditions. So this is the reaction of the law to this problem of how we deal with high-frequency trading and algorithmic trading. Of course, so the solution is basically you need to test compliance with the law. You need to test your system. So this is how regulatory technologies kicked in, trying to provide testing environment in order to test the algorithmic trading system versus historical data, but also versus antagonist algorithms. And then we will check and look at what would be the impact of these algorithmic system tests against the historical data and test against antagonist algorithms, and you will see if we find these patterns. And if we find these patterns, then it's spoofing or it's market manipulation, then it's a problem, then we need to work again on your algorithmic system. That means that the meaning of the regulation or the meaning of the rule, to a certain extent, if you consider that the meaning of a rule is the method of verification for a violation, so move from Article 12 to something that, we will not enter into that, but to something like a protocol to test if the machine can lead to market manipulation. And that's an impact of AI on law in the sense that we need, in order to check if a specific system is respecting the law, to find a way to measure, to evaluate the outcome of the system versus what the regulation provide. So from that perspective, you have a kind of new regulatory cycle in the sense that you have fintech, so algorithmic trading is one example of fintech, and then you have regtech, regulatory technologies that are there to help firm verify, certified, have some kind of quality insurance that the system they have developed will not break the law. But of course, then comes the authorities, the supervisors, and they also need some kind of tools. So that's why they decide to develop supervisory technology or subtech. So then you have fintech, they rely on regtech to check, and then subtech are using some tools also to evaluate to what extent the different algorithms that are used are respecting the law. That reshapes financial ecosystem to a certain extent, because all of a sudden everybody starts to imagine themselves as a technology company or data regulators. So you have JP Morgan, for instance, saying we are a technology company, because we are not only investing, etc. What we are doing is we are developing models, and then we go on the market with that. Of course, the regtech market is also, of course, kind of digital or technology companies, because they provide solutions to test AI systems versus the law and other obligations. But then even the supervisors start to imagine themselves as a technology company. For instance, the Financial Conduct Authority explaining that they accelerate their goal of becoming a data and digital first regulator. So they were supposed to be financial regulators, but all of a sudden they are mainly data and digital first regulators. So you can see this kind of transformation is quite huge, and with a lot of risk, of course, of regulatory capture, in the sense that if you look especially on regtech and subtech, the provider of regulatory technologies are most of the time the same people that are providing supervisory technologies. So if you consider and you accept my arguments that when you translate what it means regulating manipulation in a test, and then you have the same test that is provided by the regulatory by regtech companies, and it's the same tools that is used by supervisory by supervisor to check if there is problem on the market, then in fact you have the technological companies that have defined what the law means. Because what is market manipulation? Market manipulation is when my systems say yes. And that is one of the reasons why you have a very important risk that is identified already by a lot of actors. Here is the last report from Bank of England and the Financial Conduct Authority, saying that in 3 years, they see that the worst risk that they will face, that the different companies will face, is critical third-party dependencies. Because in fact, you have all the actors that are quite concentrated and that can lead to severe impact on the market. So now, going back to law, this evolution has changed a little bit the kind of discussions that we have in law, because traditionally, in law 1.0, the discussion that lawyers have together is that they have a case, and they decide or discuss how to apply a specific specific set of legal rules to a particular set of facts. And then you have discussions, and the venue to decide that is basically the court, because that is the place where you will have attorneys and judges that will met to a certain extent. The attorneys will bring arguments, and then they will know the answer. But with this kind of development and evolution, we are going the direction of what Roger Bronsworth called Law 3.0, in the sense that each time we have a legal discussion, the question is whether the rules are fit for purposes and whether rules or technological measures are needed and are better fit for regulatory purposes. Is it better to have a new law, or is it better to develop a new software to check for respect of the law on the financial market, for instance? I think this approach is not going far enough, because what we should have, I think, is more merging of legal capabilities and technical capabilities. Because what we are seeing is, that is the general argument, is that there is a kind of new paradigm that you can see in finance, in banking, but that you have in more and more other more and more sectors. Media is the same, the regulation of platform is the same. You have a kind of idea of smart law, scientific, mathematical, algorithmic, risk and technology-driven law, that is appearing. Because what you want to regulate, in fact, is not humans interacting with other humans. What you want to regulate is the technology. You want to have an impact on humans through the technology. That's why you regulate social media platform. That's why you regulate the algorithmic trading systems, is because you want to have an impact on the machine, because you want to regulate humans through the machine. So, of course, for lawyers, it's a very surprising thing, because then you look at the law completely differently. And that is a thing that we have done, we are doing in the Smart Law Hub, is to say, okay, what does that mean to look at the law from a computational perspective, and how you can improve the legal tools that we have from this perspective. So we are developing solutions to test legislation, for instance, okay, how complex it is, so at the formal perspective, from a formal perspective, it means, for instance, how many cross-references do we have? But also from a more logical perspective, how many agents or how many institutions are involved in the implementation? Can we not make some kind of simplification at this level? And this is a kind of reflections that you cannot have when you are just reading the text. You need to extract information and to have a kind of a dashboard to have a more general perspective on what's going on. It's the same with court decisions, where you can have some insight that was not there before, because you can work at the level of all the cases. So, for instance, you take all the cases. In this case, this example, you take all the cases, and then you put the cases together if they quote the same number of articles. And then you will have some kind of segmentation. And on this segmentation, you will identify who has win, who has lost the case. And then you will have an idea of how complex is this case, because you know, in general, how many the people demanding or going to court are winning, and how many people are losing the case. So that is just to say, we are in the legal, in the world of law, we are evolving in the way we approach the question of how we look at law. That is a kind of evolution that is going on. And it's not only in research, it's also what is going on in, let's say, in the official institutions, regulators, and even policy forum, with this idea that sometimes we need more rules as code, to take the general expression. So that means that this is a kind of movement saying, okay, we need to have some kind of co-drafting or some way to produce at the same time a text in natural language, but also a text in computer language. Why? Because we have to reduce what is the translation gap. Why do we have to reduce the translation gap? Because in fact, a lot of laws that are adopted or regulation that are adopted aims at being implemented in the IT systems of companies. So, for instance, you adopt new rules regarding some aspect of compliance for banks. Everybody knows that in the end of the day, the idea is to integrate that in the IT system. How it works now is that you have a text in natural language, then it goes to the legal department make an interpretation, then this interpretation is sent to the people in the IT, they see how they can somehow integrate that in the system, and then they integrate. So since anyway you have to integrate that in the machine, then why do you not provide the text or the regulation in a machine-readable format or consumable format? That's the idea of rules as code. And the idea is, of course, to circumvent the role of the lawyers as a modem. You know, it's a modem because it's translating the obligations that are in the legal text in some kind of requirement, and then the technical people can translate that into the IT system. So you will say this looks really bizarre. At the same time, it's not only an idea from the people of the OECD, etc. It's already completely integrated at the European level. The expression is a little bit different. At the EU level, we call that digital-ready policies and legislative acts. But there is this idea that we need to, as you can see, they say, address the gap between policy formulation and its digital implementation. And in order to do that, we need to have digital ready and interoperability by design policy setup. So this is really a kind of trend that's going on. That means that we want it, we don't want it, that's a different question. But some aspect of the law will be more and more designed and defined, taking into account the fact that it will be integrated in computers. So that is what AI does to law. So what should law do to AI? Should law disrupt AI? So that is a little bit what is happening sometimes. So we have more and more enforcement measures that are taken in different places. So in regarding finance, you have seen maybe that the regulators have caught, for instance, Wells Fargo and other banks in probe of a mortgage pricing discrimination because of using credit scoring in a certain way. You maybe have seen that the FTC in the US have developed a very kind of doctrine, what they call the algorithmic disgorgement, with this idea that if you use data that you do not acquire properly to train your model, you will not be only fined, you will not have only to erase the data, you will have to erase the model that you have built. So this is kind of strong enforcement measures that may have already kind of impact on how seriously you should take law if you are developing some kind of model. And if you look at this very recent report from the OECD regarding the risk that are identified in finance with AI, you can see that most of the risk, in the top 5, most of it is about law, breaking the law. So the first one is cybersecurity, but after that is market manipulation, bias and discrimination, data privacy, etc. So you can see that there is this concern, and I think that's what law should do to AI. There is this concern that it's fantastic to have these models, to have the AI, etc., but we need to be sure that the system are tested against the laws to prevent violation of rules. The first reaction to that, of the regulators, how to address this kind of question, was to say, okay, we need to have some kind of approach with some kind of general principle, ethical principle. So already in 2021, the Bank for International Settlements issued some kind of guidance in order to identify emerging industry best practices on AI governance, were available for each of these generally accepted principles. So they have kind of generally acceptable principles, these 5 principles, and then they try to identify, okay, what works, what doesn't work, what are the best practices that are emerging, and how this is related to law. Of course, you have exactly the same kind of evolution in the insurance industry, where they have the same kind of problems, because most of the time they have the same kind of strict regulations, where they have tried also to identify the specificities of the insurance sector, and to create some kind of key governance pillars for ethical and trustworthy AI in insurance. So there is this tendency, there is this trend, but of course this is not enough, and this is not enough because that doesn't help to understand what do you have to do. So in the recent report published by the US Department of the Treasury, you can see this, it's a kind of survey. And you can see that the respondents, what they are complaining about. The problem they have is that, okay, we know this AI system may, for instance, exacerbate discrimination. But what they need to have is to have the regulator requiring explainable AI models and identifying less discriminatory alternative. And the respondents also underline that they need clarity from regulators on what the less discriminatory model would look like and what corresponding metrics or standard firms should use to evaluate AI models. So the need from the market is good to say, okay, we will be ethical, we will not be discriminatory, we will have all these big principles, but nobody knows how to implement them, and that is a problem. This is a problem also at the European level, just to show you it's exactly the same kind of issues. So the European Securities and Markets Authority has issued in May a public statement on the use of AI in the provision of retail investment services. And you can see that what they have underlined there is that investment firms should include testing of algorithms and their outcomes for accuracy, fairness, reliability in various market scenarios, and that they need also to organize training to cover potential risk, ethical consideration, and regulatory implications. And then you have these footnotes that I have put just right there, this one. The term fairness encompasses the imperative to avoid any form of discrimination and to ensure equitable treatment across all demographic and socioeconomic groups. Are you going to do that? So then we can ask to people doing optimization how they can guarantee that it avoid any form of discrimination and ensure equitable treatment across all demographic socioeconomic groups. Can be very complex. And then concretely, the question is, okay, what is that? So what is fairness? Which one of these description would you use in order to test your system? Or how do you define in a way that you can implement? It's not easy, but that is the challenge. Because it's nice to be ethical, but at some point you need some kind of legal certainty. But legal certainty, when you regulate machines, cannot be just a piece of paper. You need to have something that you can really implement, and then you can test your machine and the outcome of your AI system. It's getting even worse with the development of Gen AI. Gen AI in finance, where you start to have a lot of different use cases that are developing, of course with the big players, but also the European central banks as some use, for very basic drafting thing. So you have different Gen AI use cases, and there the regulators are even more, in a even more complex situation. Because here it's the Security and Exchange Commission and again the ESMA. They say, okay, the Security and Exchange Commission say, okay, we are used to regulate individual institutions. That is our business. That's what we are doing for a long time, but we are not used and we are not experts at regulating basically horizontally something like a model. While we identify that there is some risk, potentially systemic risk, because there is a risk for that you will have a limited amount of underlying base model that will be used by all the different banks and all the different financial actors. So if you have some kind of problem in the 5 big models that I use, and they are biased in some way, or they are aggregating the same data, etc., you will have problem in the whole financial market. And this is the same thing that the ESMA is saying, increasing reliance on tools developed by a few big players, which bring forth operational and dependency risk within the financial industry, because everybody will rely on the same limited amount of Gen AI models. So how do you address this kind of problem? And there, the idea that you can see, and this is the Singapore answer to that with the MindForge project that they have developed, is okay, then what the regulator has to do is to define a reference architecture for Gen AI. If you want to use Gen AI in finance, you will have to respect some kind of different principle at different level, and then we will provide you with this reference architecture, and you need to follow this one. So again, it's very bizarre to have a supervisory authority providing an architecture for software. But that's the only way to regulate, so what they are doing. So, and now the AI Act is coming. So the AI Act is an additional layer for banks and insurance of obligation, because the idea of the AI Act is that we have to guarantee that the AI systems that are put in the market or put into service are respecting the essential requirements for health. That's okay, it's always the case. Safety, but also fundamental rights. Then how do you evaluate if an AI system is respecting or it's not putting too much risk for fundamental rights? That is not easy. Of course, it's a limited, this obligation is only for high-risk AI systems, and in the financial system, that means basically that will apply basically only to AI systems that are used for credit scoring, and in the insurance sector for risk assessment and pricing in relation to natural persons. But anyway, for these 2 use cases, you will have to find a way to guarantee fundamental rights, or to take into account fundamental rights. That means that the AI Act will impose you a lot of different obligations to evaluate the quality of training, validation, and testing data set. You will have to test your system and to identify the best risk management measures. You will have to perform bias detection, fundamental rights impact assessment if appropriate. So this is again a lot of obligation coming from law that people in computer science will have to deal with, because Otherwise, they cannot go on the market with their product. And what is interesting is that you have already different actors. So I took here the case of the Netherlands. And they consider that the AI regulation, so that it would be good that the same obligation that you have for high risk is applied for any kind of system used in the financial sector. And the IFM and the DNB fully support this approach. If you have a system, we should follow this kind of broad principle and the obligation of the AI Act for any kind of system that we use in the financial and the banking sector. So testing for compliance with fundamental rights, that's a very huge topic and with a lot of debate. So I'm on one side of this debate. I think that we will have to develop metrics, otherwise other people will do it. So I think lawyers should be involved in that, but some people will say, but it's not possible because fundamental rights is necessarily and always should be evaluated in context. So you cannot have metrics on that because it doesn't make sense. Because the proportionality test, etc., should be done considering the specific case. I think this is completely correct, but it's not because the other approach will lead to something different that it will not be the one that will be followed. So I cannot imagine that we will not have at some point some kind of tests of conformity assessment that includes metrics that will evaluate respect for fundamental rights. Because otherwise, you will have exactly like you have today on social media, other people that are not public that will define the laws about freedom of expression, for instance. So we need to have some kind of test there. How well computer scientists are prepared? According to me, really badly. So this is the last paper that were accepted for publication. We have evaluated the curriculum in computer science in Belgium, all of them. And we have tried to identify for the 7 broad requirements that you have in the AI Act. How much of this is covered somehow in the different class that the people get. And basically, bachelor program, so you have huge deficiency. 84% of the program are covering no more than 2 requirements on the 7. And for master program, is 60% still address a maximum of 4 ethical requirements. So computer scientists are not prepared, and that I think is something that we need to think in the university, how to take that into account in the curriculum, because otherwise you will have people that are not able to produce system that makes sense considering the obligation that we have from law. The good news is that VUB is ranking quite well in this study. So the other aspect of that is the expanding role of lawyers in the machine learning pipeline, with this idea that basically you need to have some kind of legal consideration from the design of the model. I think this is necessary because otherwise you have what people doing today working in data protection have, is that people comes with something completely finished, it's done, it's fantastic, yes, but and then they ask questions, and then there is a problem, of course, because they did not consider this, and that. And then they are identified as the people that do not help the company or the administration to do the work. So if you want to prevent that, you need to have some kind of work of lawyers at the level of the design of the system, the development of the system, the evaluation of the system, the operation of the system. So the whole, basically the whole life cycle of the AI system, you should have some kind of lawyers, can be maybe not lawyers but computer scientists with some kind of legal background that can provide advice and take into account legal requirements. So on this point of view, how well lawyers are prepared, I have no numbers for that, but I have an idea from from discussing with lawyers quite regularly. They are not ready either to do this job. That's why the way forward, and that would be my conclusion, is probably to move from this tale of two arrogant mindset into more cooperation, and I'm really happy to have started this cooperation with Sam and Matthias on this legally aligned machine learning models in finance. I think that's a step to try to find a way. Of course, it's not finished, it's not perfect, it still needs a lot of research, but to find a way to bring the obligation of the law inside the work, concrete work that people in machine learning are doing. Thank you very much.
Time for questions.
Hey, so I actually have several questions, but I will do one at a time, maybe it's easiest. So the first one is, you said we are regulating systems, and therefore we are not that interested in what the paper of text says, the law, but we want machine-readable solutions. And my question is, when do you think this method hits its limits, let's say? Because I think a lot of law, especially rights of individuals, is deliberately defined very broadly, so that you do not have to decide on a million use cases in advance. No, as they arise in the future, as new edge cases come, then you can interpret the law because it's broad. And so I think in this case, the example you gave focused on a very specific application, and then machine readable makes sense. But when would you say, like when are we hitting the limits of this?
Yeah. Well, I think there is a lot of limits. I mean, I'm not suggesting to transform all laws into machine consumable rules. But each time we decide to use legal tools to regulate machine, we should consider to potentially provide better guidance than what we are doing today. Then you have also in this, from this perspective, different level of constraint that you could put. You can decide, okay, you have to respect this and this metrics and reach this level. That's kind of very strict. But you can also give a kind of idea of the direction where you want to go. But I think the problem is that what we can see is that when you do not do that, you really leave the opportunity to all the private actors that have no legitimacy to do that, to define what are the rules that are effectively implemented. Because, so if you take the example, because it's also kind of hype today on social media, we have regulated social media. We have done that before. We have the Digital Services Act. So how we do it? We just provide some kind of general ID, and we create some kind of liabilities. We say, okay, you will be liable if you do this, and then you do that, and you should take into account this, and have some kind of proportionality. So then what the companies are doing is that they are developing systems that will decide whether when you post something online, it will be distributed, will not be distributed, will go to a lot of people, will not go to a lot of people, etc. All that being some kind of interpretation, when they implement an interpretation of freedom of speech versus other fundamental rights. So knowing that we have more and more of our interactions that are mediated through digital technologies, I think that we cannot only decide the general abstract rules in the book and let all the interpretation that will decide what in fact is implemented to the different companies that are basically trying to comply. Otherwise, because the thing is that in general in law we are focusing on judges, but judges is really rare. Most of the time, people do not see a judge, do not see attorneys, etc. But it's not important because we do not have these rules so that they are applied all the time. It's more rules to fix problem when you have. when you try to regulate the technology, you do not want only to have rules when you have problems. You want to have these rules implemented in an ecosystem because you want to push forward, for instance, a specific culture of compliance or specific values. And there, if you only have the idea that one day, maybe in 10 years, you will go to a judge, I would say the incentive is not enough.
Okay, yeah, I agree. I think so then in this guidance, wouldn't it make sense that because to some extent, if you offer this concrete guidance, you are also taking away potential for competitive advantage or something, right? If you use one machine readable format and you say this is how you should implement it. So then wouldn't a better way of guiding be, let's say you have all these options. None of these options will be perfect because they are a reduction often of what the law represents. Like you have to implement in advance this culture, as you say. It doesn't mean it will always work out, but most of the time. But shouldn't it then focus on what this specific technique you suggest does? And more importantly, as some said, we are working on this in future work. What does it not do? Because you are reducing it, so you need to kind of understand what are we missing here. No?
Yeah, I think this is the thing about it's. So the first step, that's what the Act is doing, is that you have to document. So this is a way to already say, okay, you have to document and to document everything, so that you can at least explain what you can do, what you cannot do, what is the hypothesis behind your approach, etc., etc. Is that the direction that you want to go? So this is the compliance documentation burden that we have. I think it's a beginning, but I think in some specific, and then the problem is that we need to be very specific. In some specific case, I think you need to have very stringent obligations, and sometimes it can be that you cannot use specific kind of methods in order to do this. For instance, I think that sometimes machine learning can be problematic for the security in critical infrastructure. Because maybe for this one, you don't want to go this way. That's why when you are in an airplane, there is never a problem with the code, because the constraint on the code are so high and you have so many verification, etc., that the thing is always working. You will not have a problem with your machine. But at the same time, it's not fancy. The kind of software that you have there is not fancy. We have that already in several industry, and you have some obligations also for medical devices, etc., etc. So I think that the more we have digital technologies out there, the more we need to go through all the different aspects and identify what is important, what is not important, what kind of method can be or cannot be used, and also if you decide to use it, maybe to suggest some kind of minimal requirement in order to deploy.
And so then ultimately, I guess the argument is supervisory authorities, and I'm just asking to check whether supervisory authorities provide guidelines to steer this culture of compliance, but let's say the fallback is then the judge if it goes wrong, which should be the exception. And just for this reason, supervisory authorities provide guidelines that are not binding because of this culture, and at the end there's still the fallback option. That's how
you can still go to the judge. That my idea is not to say then you can not go to the judge. My idea is only that we need to have some additional layer there. And today will be done through technical standardization. That is the way it will be done with the Act. But the problem is that technical standardization is again mainly done by the industry that are directly involved in a specific sector. And this is a problem because it's not a problem when you regulate, when you want to have an impact on safety, because most of the companies are, I mean, it's important that that basically this item that they sell, but that it will not explode in my hands. It's also important for all the people from the industry, so they have an interest to have safety. It's not always that clear that they have an interest in respecting and protecting fundamental rights. So then this kind of forum where you have today these kind of discussions that are taking place, where you need to have, I think, a kind of reform and more people involved, and that is a very big bang, in order to take into account other values than only health and safety. But I don't have a whole plan. I have mainly questions also. Huh?
Very interesting talk. I have a more speculative question. I find it very interesting that you could define these rules or these laws in a format that can be processed by machines, because it probably would also give rise to the possibility of analyzing the impact of those rules prior to them being implemented, if you have some knowledge of the system. Can you envision also perhaps the fact that we have models that can generate these rules? So that is, authorities would delegate the creation of rules to control technology.
We can imagine. I mean, I think that, for instance, when you have to check or to test your algorithmic trading system versus antagonist algorithm to see what will be the outcome, it's already going in this direction, because if you have the outcome that is not good because of the antagonist algorithm, that means that the way you have developed your system is not correct, so then you need to do some kind of the optimization. You have that already in contract, because with contract, you can, for very simple contract, you can already simulate and see what would be the impact of a provision like this or a provision like that, knowing what we know. So this is the dream of it's the dream of the engineers for a long time, to be able to basically having test bed for laws and having more evidence-based laws, etc., etc. I think in some aspect of what is developed today, we are going a little bit in that direction, knowing at the same time that I think that it's very dangerous, because all that is scenario, it's everything being equal, etc. And we know that nothing is never equal. So that is a little bit also the limit of that. But if you look at what they are doing in France, you have Lex Impact. What they do is that they simulate the impact, the fiscal impact on different kind of people with different revenues, different families, of the laws. So it's a service that is offered to the member of the parliament when they can ask to have some kind of simulation on different options to change tax law, etc. And they will see, based on the statistical data of the INSEE, etc., but they can play with, okay, what if we do this, what if we do that, who will be the most affected, etc., etc. So there is something going in that direction.
Does that make them more accountable of the decision?
Who? The member of the parliament? But they are accountable each time you go to vote.
Are there any more questions? Let's thank Professor Gregory once again.
Thank you.